Julian, good morning.
Good morning, Jonathan.
I understand we've both recently been analysing how COVID-19 impacts upon contractual obligations in a property context. I was hoping we could discuss one aspect of that for a few moments. Seems to me the law doesn't always fit neatly into watertight compartments here, but broadly, I think it can be helpful to view a situation such as the present pandemic as falling within three possible prisms. Number one, frustration. Number two, supervening illegality. And number three, force majeure. I've really enjoyed the Wilberforce web chats on the first of those two areas. It's the third area which I thought we might discuss for a few moments.
Yes, I mean, actually, force majeure is logically the first of those three that one should consider because, of course, if the parties have made a contract which deals with these sorts of issues, then there may well be little or no scope for the common law doctrines of frustration or supervening illegality to even apply. So it's a good starting point.
Yes, that sounds sensible. So where do we start? Basic definition, I suppose. What is a force majeure clause? Well, the expression itself comes from the French law. If you look in the English law textbooks, they tend to say, not overly helpfully, that the expression has no clear meaning in English law, but they then do go on to attempt to give some definition. A force majeure clause, in short, is a contractual term which excuses or suspends a party's performance of a contractual obligation on the occurrence of a specified event or events beyond the control of the party in question.
Yeah, so I mean, by these clauses, parties are attempting to make express provision for what is going to happen if performance becomes impossible or at any rate harder by reason of some particular unforeseen event like COVID.
Of course, they're fairly common in some contexts, for example, sale of goods, but I'd say they're probably less common in a property context. Would you agree with that?
Yeah, I would agree, but they are nonetheless relevant, I think, to us as property lawyers. I mean, if you take the most obvious types of property contracts, I agree, you don't normally expect to find a force majeure clause in those. I'm thinking of a straightforward land sale or a lease for that matter. I mean, there are clauses in many leases that perform some of the same functions. An example might be a clause suspending the tenant's obligation to pay rent in the event of an insured peril. But that's of much more limited effect, and it's not likely to offer much assistance in the context of something like COVID-19.
But these sorts of clauses do crop up in some property contexts, don't they?
They do. No, they do, Jonathan. I mean, in fact, they're quite common, I think, in certain conditional land sales. I mean, an example might be an agreement for lease, let's say, that contains an obligation on one or other party to erect a building or carry out some refurbishment works. Now, particularly if that obligation is to carry out works within a fixed time period, there'll often be a clause in the agreement that confers an extension of time for the carrying out of the works in the event of certain unforeseeable events getting in the way. I think the other example that occurred to me is that there are many different types of bespoke arrangements relating to the use of property where you might find these clauses. An example might be a long-term license arrangement by which, let's say, an airline block books hotel accommodation, something like that. You might well find a force majeure clause.
And of course, I suppose it's important to remember that there's no magic in the phrase force majeure itself. It's not a term of art. So you're not just looking for the label.
No, absolutely. I mean, it's a point you made earlier. They take many different forms. You can't afford to just be looking for the words force majeure. I mean, for example, I've seen an agreement for lease that contains a clause providing for extensions of time for the carrying out of works on the occurrence of defined delaying factors. I mean, that is a force majeure provision in all but name.
Yes. So I think the next stage in the analysis is to consider how you know if one of these clauses has been triggered. It strikes me there are two fundamental questions. Number one, does the particular event in question conceptually fall within the scope of the clause? Number two, in what way must the particular event or situation interact with a party's contractual performance if the clause is going to apply? Now, I think, Julian, you've been giving some thought to that first question.
I have, indeed. Now, I mean, look, needless to say, it all really depends on the interpretation of the clause that you're dealing with. Some force majeure clauses will, in fact, expressly refer to epidemics or disease among the events that are capable of triggering them. Well, in that case, COVID-19 seems highly likely to meet the test. More often, though, I think, force majeure clauses don't expressly refer to epidemics or the like. There will usually be a list of certain events that trigger it: war, riot, earthquake, flood, and so on. And that list very commonly includes acts of God. So I suppose the question that arises is, does that include COVID-19?
I mean, if you're talking about an act of God, one would have thought you're talking about a natural event rather than a man-made event.
Yeah, I think that's right. I think that's the key distinction, actually. I mean, an act of God has been described in one of the cases as a metaphorical phrase used to describe those events which involve no human agency and which it was not realistically possible to guard against. That's what Lord Hobhouse said in a case called Transco and Stockport in 2003. And I suppose, leaving aside some of the conspiracy theories, perhaps, COVID-19 seems pretty likely to fit that description. It is a natural disaster in any meaningful sense, even if it's a disaster on a sort of microbial scale, if you will.
I suppose, of course, to play devil's advocate, one might argue that it is possible to guard against COVID-19, for human agency to intervene and prevent it. Certainly some countries have been quite successful in that regard.
They have, but I think at this stage of the analysis, attention is really being directed at the question of whether you could guard against the very emergence or existence of COVID-19 per se, which it seems to me is almost impossible, in the same way that you can't guard against the occurrence of a hurricane or an earthquake. So I think on that basis, it's at least likely that COVID-19 is going to qualify as an act of God in most instances.
Okay, so if COVID-19 is capable of engaging one of these clauses, we then come on to that second question that I mentioned. In what way must the situation interact with contractual performance if the clause is going to apply? Well, there needs to be a causal connection between the event on the one hand and the party's ability to carry out its obligations being made more difficult on the other. Beyond that, you'll want to focus on the particular words used. So if a provision is formulated in terms of performance being prevented, does that mean simply not viable economically? Or does it mean something more fundamental, namely fulfillment of a contractual obligation being physically or legally impossible? The case law indicates, it seems to me, that the latter stricter interpretation will tend to be adopted if the parties have chosen a prevented formulation. See Tandrin Aviation and Aero Toy Store for a recent case on that. But it's not the only possible formulation. The clause might refer to performance simply being hindered. And if so, then the threshold for the provision coming into play will be lower.
Yeah, and I think in the context of COVID, actually, Jonathan, these distinctions are going to be potentially decisive. I mean, if the clause only applies where performance is prevented, as you say, that's a pretty stringent test. And if we go back to the example we were looking at earlier of a land transfer conditional on the carrying out of works, well, it's not necessarily certain that COVID-19 did actually prevent work from being completed. I mean, the UK government response to COVID obviously has involved a whole range of measures being put into law, but most obviously the so-called lockdown. But the main relevant piece of legislation on the lockdown, which was the Health Protection Coronavirus Restrictions England Regs 2020, didn't, for example, force construction sites to close at any point in time.
Well, that's true, though in practice, I think a good deal of them probably did close, at least initially, and if only briefly. Of course, there might have been other aspects of the COVID situation that prevented a programme of works being completed on time. For example, difficulties faced by the workforce in travelling to or from the site, or the inability to secure supplies, or perhaps the sickness of the workforce.
Yeah, I mean, I think that's right, Jonathan, and it will obviously require careful analysis of each clause and of the facts in each case. But I suspect that the full lockdown we all went through in March and April may well have prevented many forms of contractual performance in a property context. But, I mean, the situation is only getting more complicated at the moment because, of course, the lockdown is gradually being eased.
Well, that's true. Fewer activities are now outrightly prevented, I suppose.
Yeah, and of course, on the other hand, if you've got a force majeure contract clause, rather, that is triggered where the event is merely hindered or delayed performance, there's a much greater chance that the clause will be engaged, even while the lockdown's being eased. I mean, I've got in mind there the fact that there are some well-documented examples of ongoing shortages of certain types of construction materials due to factory shutdowns. And ultimately, if you can't get the materials to do the work, that will delay you, and you may well be entitled to some sort of extension of time under one of these clauses.
Julian, it's been really interesting. I fear our time is up. Before we end, just one slightly left field thought to throw into the mix. I note that last month, the Cabinet Office brought out some potentially relevant guidance. It's got a catchy title, Guidance on Responsible Contractual Behaviour in the Performance of Contracts Impacted by COVID-19. Its legal status might be up for debate. It's non-statutory, but its message is clear. Parties are to behave reasonably, cooperatively, and in a practical fashion in dealing with force majeure clauses, amongst others.
Yeah, but very interesting, Jonathan, to see how, if at all, the courts get around to assimilating that. But it's been good chatting to you. I hope you take care.
We'll leave it there. Bye, Julian.